Hello and welcome to Law and Society. I am going to today talk briefly about one of the other responses by Jack Smith to one of Donald Trump's other motions uh, to uh, strike all references of January 6th from Jack Smith's prosecution. That was the motion that Donald Trump filed. So if you're new to my channel, please like and subscribe and let's dive in. I missed this one because this I talked about all the pretrial motions in my episode yesterday, but as I was talking about that, news came out more about uh, Jack Smith's response to Donald Trump's motion to strike references of January 6th from the criminal proceedings. Well, Jack Smith responded by saying that that's not possible, that the January 6th violence and the riot was part of Donald Trump's plan to obstruct the certification of the votes. So the obstruction case is built not just on Donald Trump's parallel conspiring with members of Congress to push through a fake elector scheme. But it was also on the other side to both distract and enable the stalling of the voting and intimidating members of Congress by attacking Congress. That was part and parcel of Donald Trump's conspiracy, criminal conspiracy. Now, Jack Smith has taken a very conservative, narrow approach to indicting Donald Trump. The conspiracy charges against him are relatively broad conspiracy charges and not specific conspiracy charges like a seditious conspiracy charge, which scholars say has to include a violent component. But the two most recent seditious conspiracy cases, uh, the Oath Keepers with Elmer Stewart Rhodes, and then uh, Proud Boys with Enrique Tarrio, none of them had committed any sort of violence, but the conspiracy and the preparation was of some sort of a violence. Now, here, as I've said before, I believe that Jack Smith didn't go for a seditious conspiracy charge because he wasn't able to make the link between Donald Trump and the fact that uh, his mob was armed and that Donald Trump in the conspiracy calculated the violence factor when he was conspiring. So it's not that that didn't happen. It's simply that I don't believe Jack Smith was able to come up with that evidence. Or Jack Smith believed that he did have that evidence, but barely, and may result in a hung jury, but a broader criminal charges of criminal conspiracy to defraud the United States and to obstruct criminal proceeding and to deprive rights under color of law. They were broad enough that they would bring in other evidence that would come in alongside with other evidence from other sources, alongside with uh, information about the riot and information about the fake electors. So now, because it is such a big, sprawling conspiracy, like the Oath Keepers conspiracy and the Proud Boys conspiracies could be honed down as subplots to the larger criminal conspiracy that Donald was playing of overthrowing our government. Those two components, Oath Keepers and Proud Boys, they went further and they conspired amongst themselves to set in motion the possibility of violence. And so the facts and the evidence doesn't directly prove that Donald Trump specifically also had that intention of the violence being part of it, because that would mean that there would be a connection between the seditious conspiracy people, the Oath Keepers, and Proud Boys directly with Donald Trump or through Roger Stone. And so far, it doesn't seem like Jack Smith has been able to establish that. And therefore, the charge has been brought against Donald Trump and some co-conspirators whom we don't know. And it has been brought under the broad criminal conspiracy statute. So, but the motion was to exclude the January 6th reference completely. And, they said that it's prejudicial. Now, there is a prejudicial aspect to it because of all the violence that happened, because Donald Trump didn't directly go and tell them specifically to commit that violence. He hurtled them towards towards Congress, but then he didn't really specify, this violence. But the fact that he pushed the crowd to Congress, and Congress was delayed by more than 3 hours, much more than 3 hours, because the insurrection went on for 3 hours, and then they had to get the place back in order so official proceedings could restart again. And so they didn't start and they didn't end until I believe it was certified on January 7th, not January 6th. So they delayed it by hours. And that delay, that obstruction of an official proceeding to prove that charge, that indictment of obstruction of an official proceeding, even if not to prove that being part of the whole conspiracy, that information is critical. And that information is what Jack Smith is going to present for proving the charges, at least the charge of obstruction of an official proceeding. Now, I believe that Judge Chutkan will rule in favor of Jack Smith. I also believe that it's very likely that Donald Trump will take this up to appeal. And as I've talked about with the appeals, DC Circuit most likely will also agree with Judge Chutkan. Mind you, this all falls under the broad umbrella of the trial court, the district court, trial court that has this case, having broad discretion over how to manage the case and how to address the pretrial motions. Generally, these motions are denied or granted, and they are appealed after the case is concluded in a cumulative appeal after the verdict has been rendered. But Donald Trump is doing them interlocutory, meaning while the case is going, pushing it to the higher court and telling the higher court that you should stay the lower court's proceedings, insofar as even pushing March 4th, 2024 trial date more, pushing it back, pushing it back in the sense of, indefinitely after the elections. So that date is critical. And the appellate court has to keep that date in mind, has to keep district court's broad discretion in mind when they are ruling. And so it has to be expeditious. And the motion to stay, any motion to stay the lower court's pretrial proceedings should be denied by the higher courts, like the appellate court. The appellate court should not stay Judge Chutkan's court proceedings like they put a stay on the gag order. Mind you, that's another motion. That's the gag order. So the confusion that hello Robert, thank you for being here. Deb, you had the confusion with all these motions coming. So the important thing to remember is Donald Trump is putting up motion after motion after pretrial motion to dismiss, to dismantle, and to that's the best way to fracture Jack Smith's case. And at every turn, Jack Smith has successfully been able, at least in his arguments, to present a better case for the government. Now, we saw the gag order being reinstated and then it being stayed by the appellate court again. That's not to say that Judge Chutkan did anything wrong. It's standard procedure for appellate courts to stay the issue that is being brought up on interlocutory appeal. But this is a criminal proceeding, and interlocutory appeals are rare. I don't remember studying ever or hearing about amongst prosecutors of that happening. It's clearly not disallowed because DC Circuit has taken the appeal. So it's important to remember that there are these motions that Donald Trump is throwing out before the actual trial can even start during the pre-trial phases. And for each of these motions, the government, Jack Smith, has to reply. And then Chutkan has to make a ruling. And though generally those rulings are, whoever they're against, they preserve that appeal for after the trial has ended, Donald Trump is choosing to take them up on appeal now in an effort to tell the higher court to stop the proceeding in Judge Chutkan's court. That kind of succeeded with the gag order motion because the gag order appeal was about the gag order. It's not about the substance of the case, or it's not about the materials from the striking materials from the case. This one is specifically about the gag order, so the DC court can study Judge Chutkan's reasoning behind imposing this narrowly tailored gag order. With the other motions, they will go through the same process of getting a judgment from Judge Chutkan. Then, as Donald is doing, he's going to push them up to interlocutory appeal to the higher court, DC Circuit Court of Appeals. But I would say that the DC Circuit Court of Appeals wouldn't, in the interest of justice, stay Judge Chutkan's pre-trial proceedings, which has the time clock of March 4, 2024 being the jury trial date. So, because in my mind, in the argument for not staying the proceedings is that it's an ongoing criminal proceeding. Those that can continue while these appeals, the interlocutory appeals, are being heard. They don't have to stay the substantive case to hear those other issues, because those issues are sort of hovering, dismissals that the higher courts can deal with while the process is happening. They are not about the process. Somehow the gag order, the appeal for the gag order, DC Circuit has taken that up because it's a novel case. And I believe that with each of these cases, DC Circuit will deal with them individually. And if they can obviously go ahead and put a stay on Judge Chutkan's proceedings, but I don't think that would be, that would be stare decisis. That wouldn't be as law happens. That wouldn't be standard practice at all, because you are now the appellate court is now stopping the substantive case from going forward from the pretrial phase to the trial phase. So that's my understanding of what's going on with Judge Chutkan's court and with Jack Smith's motions and with Jack Smith's responses and Donald Trump's motions. So we have to, And obviously, if Donald Trump loses in the DC Circuit Court of Appeals, he will appeal it to the Supreme Court. And if the Supreme Court hears none of the other motions, because there are so many of them, Supreme Court is likely to hear the government, most likely to hear the governmental immunity motion, because that was an issue that Judge Kavanaugh brought up in the concurrence of Trump v. Thompson. So I hope that clarifies the question that you had, Deb. And substantively, I'm concluding. I don't have anything to say on this topic. I will soon do another live stream on the politics of what's happening in Congress, but I wanted to come out and explain a little bit. Maybe it would help some people in understanding how sprawling it is and how specific Jack Smith and narrowly tailored Jack Smith is trying to make it, so that the sprawling evidence siphons in enough inculpatory evidence so the jury is convinced and the jury renders a guilty verdict. So that's a job of the prosecution. So I hope that clarifies. And if you've just arrived, just scroll back 15 minutes and I was talking about the motion that Donald Trump made to strike January 6th references from his case and Jack Smith's response to it. So with that said, I don't see any questions about it. I'll be back in a few.